Davis with the News Channel 8. We're wanting to know, what is it that you want to know from Donaldson's parents, and why is it so important that you speak with them?
Well, let's take a step back for a moment. We have 4 murders that we're prosecuting. So we are taking every investigative avenue and using every investigative tool at our disposal to build as strong a case as possible to hold the defendant accountable for his crimes.
They are apparently, at the moment, willing to even risk going to jail to not answer your questions.
I'm a father, so I recognize and sympathize with the unenviable situation that they're in. But we have an ethical obligation to exhaust every investigative avenue to make sure we understood what happened in this case. And keep in mind that we're not only trying to build a case against the defendant, we're trying to ask a broader question as well as to why, a question that the victims' families and the community deserves to have answered.
Sir, I'm Serena Pizana, and I'm the one on ABC Action News that broke the story last night with the family here in court. They walked in solidarity, told me privately that they won't comply with the subpoena. They feel they're being put in a very difficult position at this point. And I know there are legal protections where a spouse does not testify against a spouse. Some people do question the ethics behind it, of having parents testify against their son. Can you respond to that?
Yes, we have spousal privilege in the state of Florida. There is no parent-child privilege. In fact, most states do not recognize a parent-child privilege. Most federal courts do not recognize a parent-child privilege. So again, my job ethically is to do everything we can within the bounds of the law to obtain as much information as possible about this case.
We've heard this is a very rare
you want to know from the parents.
We've heard this is very, very rare, that this rarely happens. So
investigative subpoenas are used frequently throughout the course of our investigations and prosecutions.
But to the parents, but to seek an investigative subpoena against the parents, we've heard that is extremely rare.
You've heard it incorrectly. We use investigative subpoenas again frequently, and in this case, like any other case that's a capital crime or a case of this magnitude, we're going to use every avenue at our disposal to obtain the most available evidence that we have to determine what happened to bring prosecution against the defendant.
So specifically, what is it that you want to know from the parents?
Well, I can't talk generally. I can't get into strategy, as I've said before. We're going to be as transparent as we can, but I can't say anything that's going to undermine the integrity of the process. Generally speaking, however, we want to talk to any witness who may have information about what happened on the nights in question, about the defendant's whereabouts, about the defendant's motivations. So those are the questions that we're asking any witness who we believe may have relevant information about the case.
Mr. Ward, is there any indication at this point that the suspect in this case has any sort of mental illness?
I can't get into that right now, but as I talked about the other day, we're going to conduct a thorough evaluation of all the statutory aggravating and mitigating information with regard to making a decision about the death penalty, and the defendant's history of mental illness is one part of that process.
And speaking of the death penalty, what is your opinion on that at this point? Has that wavered at all since we spoke last week?
Absolutely not. If there's a legal basis to seek the death penalty and it's consistent with the wishes of the victims' families, we intend to seek the death penalty.
You're going to be speaking with the parents later today. What is it that you want to know from them? Is this going to be about the death penalty or what their wishes are?
We're going to speak with the victims' the victims' families throughout the course of this process to help them understand what's going on and to talk with them about how the prosecution is going to proceed, including their thoughts about the death penalty. This is not a one-time event. This is going to be an ongoing process in the coming weeks, months, and years.
I believe you've spoken in the past, and I don't have an exact quote, that age and mental health are huge determining factors when it comes to the death penalty. So what do you say about this case if mental health is an issue, and what do you say about the age as well? This defendant is in his early 20s.
The defendant's age and history of mental illness are factors that we are statutorily obligated to consider. They are not the most serious of mitigating factors or the least serious. We take it cumulatively with what we're required to evaluate, and we'll evaluate those two factors along with all the other mitigating information that we have.
Sir, we've heard through sources that you have an airtight case.
I'm not going to comment on the strength of the case at this time. Please understand that no charges have been filed yet.
And why is that? Why is that,
because we need to bring an indictment before a grand jury. So I'll be happy to explain Florida law a little bit. In Florida, you cannot charge someone with a capital offense through an information. It has to be an indictment returned by a grand jury. Our grand jury sits for 6-month terms. They sit usually once a week. When we have 21 days from the date of arrest to return an indictment, and we'll be doing that within the 21-day period.
Are you doing that tomorrow?
I can't comment on when we're going before the grand jury. The grand jury deliberations and proceedings are secret.
And it's my understanding that not all 4 families of the victims agree in the same way on the death penalty. So how do you approach that? How are you going to handle it now?
Well, it's a conversation that we have to have with the families. And again, it's a conversation that happens over time. There's an evolution with dealing with the victims and victims' families in cases like this, where we want to make sure they understand the process, what goes into it, and make sure that they're giving us their best opinions and recommendations about what they think the sentence should look like.
Sir, how much do the victims' families' feelings play into that, though, on whether or not you do seek the death penalty?
It's one factor that we consider, and it's an important factor that we consider, but it fits in with the other statutory factors that we're obligated to evaluate.
Do you think somebody has to have a severe mental illness to commit multiple murders like this in such a methodical way? What's your opinion on that?
Mental illness, in my view, and in my role as the state attorney, is to evaluate whether someone is competent to stand trial, and in a capital case to determine whether mental illness played such a role in the commission of the crime that it's a mitigating factor against seeking the death penalty.
With Donaldson's parents and immunity against being prosecuted for answering your questions, what do they have to lose for not talking with you all and sharing information, if they have any?
Again, I can sympathize with the parents of a defendant, especially a defendant who has been arrested for 4 murders. But as you pointed out, the parents do have immunity, just like anyone would who's given an investigative subpoena. So anything they say can't be used against them, which means that a judge will likely compel them to answer questions that are relevant to the investigation.
I'm sorry, sir. The parents' attorney, though, has said that if they do not answer those questions, they could face contempt and even end up in jail or be fined.
I don't think it's going to come to that, and we're not at that point yet. We've filed a motion for an order to show cause so that the parents have an opportunity to explain why they declined to answer questions in front of the judge.
Is this common in criminal cases where the family members of a defendant refuse to talk to you? Like, do you deal with this fairly regularly?
We deal with reluctant witnesses regularly in all sorts of cases in this community, and frankly, it's a difficulty we have in prosecuting cases. However, with people refusing to answer questions, that is a rarity, because most people understand that they have a duty to understand questions, and when that duty is explained to them by a judge, they're willing to provide answers to us.
Sir, but the parents' family's attorney, Ralph Fernandez, has said that this is putting family values on trial. It's basically asking parents to testify against their own child, posing, obviously, an ethical dilemma for them. Can you comment on that, or can you express your opinion on that?
Sure, and to be clear, no one's been asked to testify to anything. An investigative subpoena has them come in and answer questions in a private environment as part of the investigation. Mr. Fernandez and any other lawyer who's dealing with the civil side of this case is doing the best they can to represent their clients. But as the state attorney, my duties and my obligations are different. We are here to investigate and prosecute this crime to hold the defendant accountable for what he's done.
When you said it would not come down to the parents going to jail or being fined, but that is a possibility, correct, from what I understand?
It's a possibility under the law, but again, we're not at that point in the process yet.
2 more minutes, guys.
With them having immunity and not being willing to speak, do you think it's because they don't want to say he doesn't have a mental illness?
I'm not going to speculate on why the parents declined to provide information. Again, we'll have that opportunity to bring it before a judge, and they'll have an opportunity to explain their thought process about it as well.
Sir, we heard...
Both of the parents refused to talk, or is it just one of the parents?
Both of the parents, in separate investigation, in separate interviews, declined to talk. We filed a written motion against Mr. Donaldson We informed the court that we would be seeking an order to show cause against Mrs. Donaldson as well. We hadn't filed the paperwork on that yet, but the court and both Mr. and Mrs. Donaldson and their attorney are aware of it.
Sir, we've heard that we have to wrap this up. Do you have any final words in closing?
Again, we're going to keep doing everything we can to investigate all investigative leads, using all mechanisms at our disposal to build as strong a case as possible to hold the defendant accountable for his crimes, to make sure that we're seeking and obtaining justice for the victims' families, for the residents of Seminole Heights, and for the entire community. Thank you very much.